Welcome, and I am Bob Mata, the host of Defense Diaries, and I'm joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. So it's Saturday, September 6th. And what are we here to talk about?
We are here to talk about the Aaron Spencer case. If you're not aware of it, back on October 8th of 2024, Aaron Spencer, who was a guy who lived down in Lonoke County, Arkansas, reported that his 14-year-old daughter was missing after he was awakened by the family dog's barking.
In the
Goes
middle
into
of the
the
night.
room. He finds that she's not there. Parents are panicked. They call 911. Aaron jumps in his vehicle and he is able to track down his daughter, who happens to be in another vehicle with a man named Michael Fossler, who is a 67-year-old man who had been previously arrested and charged with multiple SA offenses, namely against Aaron Spencer's daughter, including internet stalking, SA, and possession of CP. And these are all again related to Aaron's daughter. Fossler was out on bond. He had received a $5,000 bond, despite the fact that he had 43 charges against him and a no contact order. Spencer, after he finds the vehicle, forces Fossler's truck off the road, and then he's yelling for his daughter to get out of the truck. She's not getting out of the truck. He's yelling at Foster to let his daughter out of the truck. She's still not getting out. Foster gets out of the truck. And at that point, some form of confrontation ensues. Fossler is shot and killed. Spencer pulls out his weapon and he shoots and kills Fossler. Spencer then calls 911. And upon the arrival of law enforcement to the scene, they then place Aaron Spencer under arrest. And he was then subsequently charged with murder. So where we're at right now, we're probably about just about a year into the case. Okay. And there's a lot of strange factual scenarios going on here. The same judge who had issued such an order with such a low bond for Fossler happens to be the very judge that is sitting on this case. So she had gagged the case early on, and she gagged
Super
everybody.
gag.
Super gag. And it was such a super gag that Aaron Spencer's attorneys went ahead and appealed it and went up to the Arkansas Supreme Court, and they flamed through the gag and the judge, both.
And judge.
And so there hasn't been a ton of filings until recently. So that's your background. And the reason that we wanted to come on today is twofold. One, this is a case that Allie and I are very passionate about. We are very much of the mindset that Aaron Spencer not only should not have been charged, but that
She
the
got a
entire
medal.
case, she get. I mean, that's how I feel about it. Like, this was not a vigilante thing. It
No.
wasn't him just hunting this guy down when he got out on bond and killing him.
Right.
This guy was out for 3 months,
Took his
and he
kid.
and
However, he got his kid.
right, he was, he had groomed the child, and we're talking about a level of grooming to where there's an outcry by the child, and he is then arrested, and he goes in and he's able to raise the bond, and he comes out despite the fact of the outcry, despite the fact that he's been arrested. He is able to sink his claws into her once again. That is the level of grooming that we're talking about. And he lures her out of the house, or he goes into that. We don't know how she gets in the truck, but whatever the case may be, it appears that she went, by her free will, on her own free will. So, we're talking about massive grooming here, and she was 14 at the time. So, it's problematic. It's problematic. Actually, I think she was still 13 at that time
Yeah, she was 13 when he
when he got her
assaulted
back.
her.
Yeah.
I'm not sure the age. I thought she was 14 on the day that this actually happened.
Yeah.
I'm actually fairly certain of it because I looked at the statute and there was some differences with the age if she had been 13 versus 14 as far as some of the charges and things of that nature.
Yeah.
And he's like disregarding that he's out on bond, no contact order. I mean, this was for any father or any parent would assume he is going to get never be seen again with my child or murder my child. Like, that's what's happening, in addition to any other abuse that was gonna take place.
Yeah. I mean, this is a thing where the Spencer family is now going through the nightmare that is this experience. I mean, when you are he is fortunately out on bond, so Aaron is not sitting in jail awaiting trial. So there's that, which is helpful in terms of dealing with this. But just the pressure, the intense pressure of this floating over their heads every second of their lives is just a lot.
Right.
And it's a
And
case that we are going to closely follow,
yeah,
and it's one that I'll probably end up going to the trial.
yeah, if
I
not
don't.
both of us. I know it's
Yeah.
hard though, and we still got one still at home. And Bob and I were talking about this off air earlier that, so in Arkansas, it's literally one of the only state, although I think Connecticut, there's some felonies that they can circumvent the indictment or preliminary hearing, where the prosecutor can charge by way of information, and you are not entitled to either a grand jury to indict you, to consider the case and indict you, or a preliminary hearing. And Bob and I were saying in this case, this might be one of the very few cases where there wouldn't come back with an indictment, ham sandwich or not, you know, like that, especially with the community knowing what they know, um, about the alleged victim here, who I think the victim is Aaron Spencer, but that's just my opinion, and I don't have, I don't know all the facts, so obviously things could change, but that's my strong feeling presently. Him, his family, his daughter, they're the victims, not the person who was shot, and maybe they wouldn't even be able to get an indictment. So it's shocking to me. I honestly thought that the United States Constitution controlled this issue for all the states, as far as either for a felony needing a grand jury or a preliminary hearing. But apparently, the grand jury clause is not something that has been applied to the states through the 14th Amendment. And in Arkansas, has universally remained firm, saying a prosecutor, as long as there's been an arrest warrant and the judge makes a probable cause determination for an arrest warrant, no need for a preliminary hearing, no need for a grand jury to indict. That's it. You're going forward. Scary. It's really scary.
It is,
Really
and
scary.
it's equally scary the fact that they have no way of forcing them to a preliminary hearing even, right? I mean, that's where it
No,
gets
you
weird.
cannot demand a preliminary hearing.
It's
You have no
crazy.
right to a preliminary hearing
It's crazy. So
in
that
Arkansas.
yeah, that introduction kind of what the current state of the law is in Arkansas is exactly what the motion that we're going to be going through today is dealing with. And this is one of those tough ones. Like Allie, and I used to talk about in law school, we're like, there are like we make bad laws. There's obviously been throughout the course of the history of our country really bad laws, and the question then becomes, when you're dealing with the concept of precedent, and that is where a court has ruled on a particular issue a certain way, and we've seen it in recent cases where very well settled law has been changed, namely like the abortion laws when the feds, when that case came down and they put the abortion rights back to the states and took it out of the federal level. That was a big change in the law, and there's been
The
over the
change in law
course.
that the law has said could never happen because of stare decisis and how firmly rooted that law was. But yeah,
Yeah, I don't. Yeah, I'm not necessarily wanting to get into that
right.
conversation,
I
but
know. I'm
I'm
just
just like,
saying.
but so what the concept of this motion is it's not because precedent that exists in Arkansas does not support the proposition that the defense is arguing here. Because as you'll see, the defense is saying this is bad law. Like, this law is not good. It's scary. Like Allison was telling you guys, giving one prosecutor just complete autonomy to go in and basically try whatever cases they want to try, arrest whoever the hell they want to arrest with no checks and balances in place. None. It's a
Because the
scary,
probable
scary way.
cause determination for a warrant, there's nobody challenging evidence. Like, yes, I understand there's no one actually challenging it in a grand jury proceeding. Like, there's not another attorney, so it's not adversarial in nature. But at least the grand jurors can ask questions. You've got multiple people whose minds need to be swayed, and not just you're going to the judge saying your typical shit, and the judge is like, "All right, rubber stamped." Like that to not have that extra layer. And as you guys all know, when I referenced the ham sandwich earlier, a grand jury is not, it's not really all that much. But Bob, like I was saying, Bob and I were talking about in this case, in this situation, there's a damn good chance that a grand jury would not indict this man.
Yeah.
But he's
Depending
got no
on
right to it.
what the prosecutor would have gone in and said, or what the prosecutor would have gone in and omitted from the story. Like, if
Right.
the prosecutor goes in and just says, "Oh, well, this guy had this, the defendant's daughter in his car, or this person's daughter in his car, no big deal." And this guy hunts him down, runs him off the road, and then shoots him.
Right. If
If
they
if they
don't
tell
know
a
that,
story like that
right.
without including the rest of the facts, because the thing about the Spencer case, in terms of Aaron Spencer's mindset, all that's
I agree,
relevant in terms
Keithy.
of the case
Keithy.
is the fact that what Aaron knew at the time. So he obviously didn't know anything about Fossler prior to. He doesn't know if Fossler's a monster that is constantly preying on kids. All he knows is
Knows
that
it with
this
his
guy
kid.
preyed. All he knows is this guy preyed on his daughter, and that there was an outcry that took place, and he was arrested, and he was charged, and he had 43 pending counts, and he had a stay away order, and somehow this guy got his daughter back in his truck. I
In
don't
the middle
know.
of the night,
I don't, yeah,
absconding with her.
12:30 a.m. So I don't know what you'd be thinking, but I'd be thinking exactly what Aaron Spencer was thinking, and I would take care of some business. So that's where we're at. Let's pull up the motion.
So
And
while you're pulling that up, one thing that is very interesting in Arkansas, and I've got to look into it deeper, is that you can make a pretrial um, assertion of self-defense and get immunity from prosecution. So I don't know how that works in practice there. It, it- maybe we can do some more digging into that process. I came across it while I was looking into some of this whole, like I said, I honestly thought the US Constitution required a preliminary hearing or grand jury indictment for felony charges until I read this. So we're gonna look into it, but it looks like it's an actual immunity from prosecution if you can um, prove certain defenses. Where in Illinois and in most places, it's just a defense that you raise at trial. So we'll have to look into that and get back to you guys on that. But that's an interesting thing to see if that's something that could happen here.
yeah, and Sky got us to ask, how did he lure her out? I don't know, and frankly, I don't care. He's a 67-year-old fucking creep that's luring a 14-year-old out of her house at 12:30, whether it's by text message, whether it's, "Hey, I'm gonna Venmo you some money," whatever. Who gives a shit? I don't care what it is.
I want to
He's a he's
apologize
a
deeply for what I
he's a
did to you.
creepy, creepy old fuck predator who's inappropriately contacting this child. So I really don't give a shit how he got her out.
I'm sure Sky Goddess doesn't either. I think she's more
I don't
inquiring.
know, but like I just
Right.
want to be clear. I don't give a flying fuck how he got her out of the house. Period. Doesn't make, like, that does not factor in what ultimately happened to this guy in any way, shape, or form. This guy was a predator of the scariest kind. This guy, like, to think about the concept of him having 43 pending charges, having a stay away order, and this guy gave zero fucks about that and went and started communicating with this kid again and had the balls to drive over to that house so that she could either run out or he comes in and gets her, whatever. And then she's in his vehicle. No, I'm sorry. No,
Yeah.
I don't care. I don't care how she ended up in the vehicle. So, and nobody on that jury is going to care either. I can guarantee you that. So, all right, let's go through it. Motion to dismiss the felony information on Fifth Amendment grounds. And what we'll do is I like Allie's going to kind of, we'll stop as we're going through if she's got thoughts on certain things, and we'll kind of break it down like that. I wouldn't call it an overly lengthy motion, but it's a complicated motion because, again, really the defense is asking for the judge to not follow the law, which isn't going to happen. I mean, I think Allie will agree this is never going to get granted. However, you have to make the record for, if God forbid Aaron was convicted on appeal, that's how you have to change the law. You have to go up through the appellate court, ultimately land at the United States Supreme Court or the Arkansas Supreme Court and have them change the law because you're saying that the law sucks. This law is no good. You're giving way too much power to a person that already has a shit ton of power. And I'm talking about a prosecutor. So the introduction is the court should dismiss this felony information because it violates the grand jury requirement of the Fifth Amendment of the U.S. Constitution. And stare decisis is not a license for the state to pursue such an unconstitutional course of conduct.
I'll start right there with a quick chime in. Stare decisis is Latin for to stand by a decision, to stand by a decision. It just means that in the law, we say when something is precedent, when the decision has been made and it's been, incorporated into the law and acknowledged time after time, you're supposed to follow that law. So here the defense is saying just because Arkansas keeps saying we're not adopting the grand jury clause of the United States Constitution, we don't think we need a grand jury or a preliminary hearing, that they should continue to follow that just because stare decisis. They're like, let's reconsider this because it's getting out of hand. And here's a damn good example of how it's getting out of hand under the facts of this case.
Right. So, two, following the Supreme Court's incorporation of the Sixth Amendment, jury unanimity, Jesus, requirement in Ramos v. Louisiana, nearly every core criminal procedural protection in the Bill of Rights has been incorporated to the states through the Due Process Clause of the 14th Amendment. So the court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by state legislatures. Three, so do you want to explain, so when they talk about the 14th, which is where due process was born, really, the concept of due process?
So the 14th Amendment, because remember, this is the federal Constitution. So, your Fifth Amendment right to remain silent, your Sixth Amendment right to a fair jury, that all gets applied to the states through the 14th Amendment. So it says, all right, and states, you've got to, this is now applying to you through the 14th Amendment. And that's, the due process clause.
So that's because you'll always see this language, which I read, has been incorporated to the states through the due process clause of the 14th Amendment. So you'll almost always see that when they're talking about the 14th Amendment in terms of due process applying to the states. All right. So three, the last unincorporated criminal procedural right is the Fifth Amendment grand jury clause. Whether to require states to comply strictly with the grand jury clause was last considered in Hurtado v. California, an 1884 case.
Wow.
I want you to wrap your mind around how long precedent can still be good law in this country. So we're talking about a case from 1884. So that precedent, if read today, in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendants of a foundational procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. They then shift into the argument. So, and Allie and I are going to split this up in terms of reading. I'll do two, you can do three. So, A, requiring a grand jury for felony charges is deeply rooted in history and tradition because it protects the fundamental principles of liberty and justice. So, paragraph 4, the grand jury clause of the Fifth Amendment to the Constitution provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. And that comes from the U.S. Constitution, Amendment 5. Paragraph 5, like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement. And so did the 1868 version of the same document. And then they cite the Arkansas Constitution. Paragraph 6, the purpose of the grand jury requirement is to, quote, limit a defendant's jeopardy to offenses charged by a group of his fellow citizens, acting independently of either prosecuting attorney or the judge. And that comes from U.S. v. McCordy, Second Circuit case from 2009. Paragraph 7 says that the history of the grand jury dates back more than 1,000 years, from the constitutions of Clarendon and the Aziz of Clarendon to the 14th century Edwardian advance in criminal procedural design. Wow, they went deep.
Yeah, I'm like, what? I don't even know about this.
Interrogating the non-incorporation of the grand jury clause, and that's Cardozo Law Review. In the 17th century, the cases of Stephen College and the Earl of Shaftesbury saw the grand jury emerge as a valued protection of individual liberty against encroachment by the crown through politically motivated criminal prosecution. 8, the Supreme Court acknowledged the venerable history of the grand jury requirement, including its presence in Clause 39 of the Magna Carta, and the debates on whether it should be interpreted to include, quote, not only felonies, but also misdemeanors and petty offenses, again, citing Hurtado v. California, that 1884 case. So, however, the court ultimately decided not to incorporate the grand jury clause against the states, holding that state legislatures were free to, quote, newly devise, quote, any legal proceeding enforced by public authority, so long as they, quote, preserve the principles of liberty and justice. 9, although Hurtado established that the grand jury requirement was not incorporated against the states, the decision did not excuse the states from ensuring that their criminal procedures offered at least some form of due process, and it did not require Arkansas or other states to strike the grand jury requirement from their constitutions. Therefore, in Arkansas and other similar states, the grand jury requirement remained. However, paragraph 10, in 1936, Arkansas amended its constitution to provide that, quote, all offenses heretofore required to be prosecuted by indictment may be prosecuted either by indictment, by a grand jury, or in italics for emphasis, or information filed by the prosecuting attorney. So there's the offending language.
Right.
That's
That's
where
just the
they
prosecutor saying some words. On
so
this stage,
and on its face, it seems like maybe it's not so bad in 1936. You're like, oh, well, that grand jury shit, they're doing that in private, and I don't know
yeah,
what
it's
they're
a ham
saying.
sandwich anyway.
I like to saw him indict a ham sandwich, do they? So you're thinking, all right, well, at least this information is public, right? It's like, so you're thinking initially in 1936, maybe it's not the end of the world. 11, the following year, based solely on the court's decision in Hurtado, the Arkansas Supreme Court found that that Amendment 21 was constitutional within the meaning of the Fifth and the 14th Amendments to the U.S. Constitution, ushering in an era of felony charges being filed by a lone prosecuting attorney. Scary. That's scary.
Horrifying.
So the state's practice, paragraph 12, of allowing individual prosecuting attorneys to charge individuals with serious criminal offenses directly controverts the Fifth Amendment to the US Constitution. It also creates the risk of executive overreach, which has no roots in the history of tradition or tradition of this country or the state of Arkansas. To protect the Fifth Amendment rights of Arkansans, I would like to say Arkansans. I'm not going to lie. Arkansans. Is that it? Arkansans.
The rights of
Uh,
people from Arkansas.
yes. This court should dismiss the felony information in this case. All right, babe. You want to read B?
All right, so
Or you want-
Section B. Although Hurtado did not incorporate the grand jury clause, the rationale of Hurtado has been superseded by subsequent incorporation decisions. So, paragraph 13. The right to grand jury indictment is the sole unincorporated outlier among the due process protections contained in the Bill of Rights. Because of the court's decision in Hurtado, which predated the era of selective incorporation. And they're citing a Fairfax case, which is a U.S. Supreme Court case that was cited earlier. B1, although Hurtado treated incorporation as a matter of procedural due process, the court, that's the Supreme Court, now applies a substantive due process analysis for incorporating the Bill of Rights. Paragraph 14. Although Hurtado is critically important to the 28 states, including Arkansas, that allows a defendant to be prosecuted for a felony without a grand jury indictment, and that's citing Hurtado, could be called into question in light of the court's decision in Ramos. Did I say something wrong? Although it's critically Ramos. Of course, Alito dissented there. Thank God. Got an outlier judge. The court's rationale in Ramos reflected the court's rationale in Timms versus Indiana, in which the court explained that that protection enumerated in the Bill of Rights, quote, is incorporated against the state if it is fundamental to our scheme of ordered liberty or deeply rooted in this national history and tradition. A close reading of Hurtado shows that the court did not deny the fundamental character of the grand jury right. Instead, the court acknowledged that the grand jury's deep roots in both United States history and traditional and English history and tradition that preceded the foundation of this country. The court recognized that the grand jury requirement was a safeguard to the fundamental principles of liberty and justice. What it rejected was not the idea that individuals had a fundamental right to be free from deprivations of liberty exceeding the limitations established by the Bill of Rights, but the idea that the Due Process Clause of the 14th Amendment required identical procedural mechanisms in state and federal prosecutions to preserve the fundamental principles of liberty and justice. So basically what they're saying there is like all the court was saying was, yeah, you got to give these same kind of rights, but you don't have to do it exactly the way we're saying. Like, you don't need a grand jury requirement. So that's the essence of what the defense is stating there. Paragraph 17. In doing so, the court avoided conflict with its previous decision in Murray's lessee versus Hoboken Land and Improvements Company, another 1855 case. In Murray's lessee, the court had held that, quote, due process requires adherence to traditional common law procedures demonstrating consistency with fundamental principles rooted in history and tradition. Had the Hurtado court followed this analysis, it would likely have concluded that replacing a grand jury indictment with a unilateral prosecutorial information was incompatible with due process. However, the 14th Amendment had only recently been ratified, and California, like other Western states, was struggling with the practical requirements of convening grand juries in sparsely populated areas. And they cite a law review. And
that's good. That's good background.
Right.
because when the legislature is trying to deal with, you got states that have different types of populations. You've got densely populated, you've got sparsely populated, trying to convene a grand jury in a cow town could be very challenging. So, I mean, in that sense, that's why when you look at really old cases and you look at how much society has changed, and it's always that argument that you can make if you get into a lofty debate with somebody about the Constitution, and you've got somebody who I would term as a what they call a strict constructionalist, and that is somebody that always looks at the Constitution through the eyes of the framers. They don't take into consideration all the changes, the fact that there was barely electricity back then, that there certainly wasn't any internet, there were no cars, nothing that we have modern existed when they drafted the thing. They don't consider that. What they do is they look at it from the eyes that the framers were looking at it, and they strictly construe everything that the framers wrote because it's their position that the framers were all knowing. So I obviously believe that there should be a more liberal interpretation, and that it has to. The beauty of the document is that it's living and breathing, and it can change. We can add amendments. We can tweak it in a way that it becomes something that works for modern society, because the bones are always going to be the bones of the Constitution. I mean, it's the bones of it are, or if you want to call it the foundation of it, of this house, is as solid as you can get. But you have to leave room for modern times, and in a realization that with that becomes new problems arise. So it's interesting to know why these things were passed originally and how they passed muster at that time, and it was based on practical considerations really more than anything else.
Yeah, great points. Great points. Moving on to paragraph 19. In that context, prior to the court's incorporation decisions of the 20th and 21st centuries, the court concluded that California's practice of proceeding on an information filed by an individual prosecutor was not sufficiently unfair or oppressive to violate the 14th Amendment. This differential procedural due process standard sets Hurtado apart not only from Murray's lessee, but also from the court's more recent incorporation decisions, in which it has reviewed states' criminal procedures as a matter of substantive due process. Spencer's motion does not require this court to overrule Hurtado, only to read it narrowly in the context of Murray's lessee. A narrow reading of Hurtado establishes that although a felony information may satisfy the minimum requirements of procedural due process, a substantive due process analysis requires dismissal of the felony information in this case. Section B2. Recent incorporation decisions establish that the Fifth and Sixth Amendment criminal procedural rights apply identically to the states as to federal prosecutions. As previously established, the Hurtado court did not find a state's process for filing felony charges to be outside the scope of the 14th Amendment's due process clause. Instead, the Hurtado court decided that due process meant any process that was legislatively intended to safeguard the fundamental principles of liberty and justice. In many years since Hurtado, the court has overruled most of its precedent from the 19th century, expressly holding that the 14th Amendment's due process clause does, in fact, require that courts apply an identical definition of due process to state prosecutions as to federal prosecutions. This trend reflects what Justice Black considered to be, quote, the original purpose of the 14th Amendment, to extend to all people of the nation the complete protection of the Bill of Rights, to hold that this court can determine what, if any provision of the Bill of Rights will be enforced, and if so, to what degree, is to frustrate the great design of a written constitution. In 2010, the Supreme Court of the United States published the following list of its decisions fully incorporating the provisions of the Bill of Rights against the state. So it goes on to say, with respect to the First Amendment, it cites a number of cases, so free speech, and then it goes on to search and seizures. With
Yeah.
respect to the
Yeah.
Fourth Amendment, search and seizures, all of that. With respect to the Fifth Amendment, double jeopardy clauses, privilege against self-incrimination, just compensation clause. So all of the clauses that they have incorporated. And they cite McDonald v. the City of Chicago in a footnote for that. In 2020, the court added the Sixth Amendment implied requirement of jury unanimity. Now I can't do it. Unanimity. You, my God. Unanimity. What the flip?
Yeah, you were just laughing your ass off when I
When
was
you
trying.
did it, yeah.
Yeah.
All right. To its list of provisions from the Bill of Rights that apply identically to the states, Ramos v. Louisiana. In Ramos, the court acknowledged that the unenumerated jury unanimity
That word's a fucking mouthful.
unanimity. Oh my God. Say it.
No, I'm just gonna let you struggle. You weren't trying to help me.
No.
No, you were just laughing.
Unanimity. I've never had this difficulty before.
Unanimity.
Unanimity.
I'll let you struggle. I mean, it took me a hot
Unanimity.
second.
Unanimity.
Yes. Yeah, almost close.
Unanimity. Unanimousness.
Boy, you're in a real kerfuckle right
The
now.
unanimousness. Unanimity requirement had never previously been applied to the states, even in, now I don't know where that is.
Where?
Apodaca?
Apodaca?
Apodaca. Oh, that's
It's
the
a
last name.
it's a name,
Apodaca v. Oregon. Oh, it's getting hot in here now with all that
Unanimity talk.
unanimity talk. Directly on point. Whew. All right. Nevertheless, the Ramos court expressly overruled Apodaca and found that the Sixth Amendment required jury unanimity both in federal prosecutions and in state prosecutions. So they're talking about the fact that if something's going to a jury, it has to be unanimous. So what the defense is doing is saying, like, the reasoning behind requiring unanimity in the jury
Wow,
should.
you're crushing that word now.
Well, I was like messing with it at
Got
that
that shit
point.
on lock.
Speaks to the fact that that there should be a grand jury procedure, that the citizens should be involved. But we'll see how they do that, moving on. It did so despite the thousands of cases in which state courts had relied on Apodaca, and despite the potentially crushing burden on the courts and the criminal justice system that fully incorporating the jury unanimity requirement might impose on the states. The Ramos court explained that once the right has been incorporated against the states by the 14th Amendment, that right cannot be interpreted to mean two different things depending on whether it's being invoked against the federal or a state government. Thus, Ramos should be read as implicitly superseding Hurtado by prohibiting states from obtaining felony criminal convictions by procedures that, although they may arguably be consistent with the principles of liberty and justice, are not identical to the federal government's criminal procedure. 4 years after Ramos, the court explained the critical importance of the jury trial rights, both enumerated.
Crucial.
Oh, crucial.
Yeah.
oh, I said critical, the crucial importance of the jury trial rights, both enumerated and unenumerated, of the First, Fifth, and Sixth Amendments. Thus, the Sixth Amendment promises that in all criminal prosecutions, the accused has the right to a speedy and public trial by an impartial jury. Inherent in that guarantee is the assurance that any guilty verdict will issue only from a unanimous jury, citing Ramos. The Fifth Amendment further promises that the government may not deprive individuals of their liberty without due process of law. It safeguards for criminal defendants well-established common law protections, including the ancient rule that the government must prove to a jury every one of its charges beyond a reasonable doubt. Together, these amendments place the jury at the heart of our criminal justice system and ensure a judge's power to punish is derived wholly from and remains always controlled by the jury and its verdict. And it's citing that's a 2024 U.S. Supreme Court case. Although the court's justices have offered somewhat different explanation for the court's recent incorporation decisions, their message is clear. States must comply with the jury requirements contemplated by the framers, or their actions will be found unconstitutional upon review by the Supreme Court of the United States. And they cite that McDonald's case for the proposition that, quote, this court has abandoned the notion that the guarantees in the Bill of Rights apply differently when incorporated against the states than they do when applied to the federal government. So I'm just going to take a pause here and say, all right, everything that the defense is putting forth here makes sense and is reasonable. However, they have not incorporated that grand jury requirement through the Bill of Rights, through the due process clause. So, but the point they're making is that there has been a new trend, and the recent Supreme Court decisions say we want people treated the same, whether they're being prosecuted federally or they're being prosecuted in a state, and that if considered today, Hurtado would be decided differently. That is what they're saying. So the arguments they're making, especially to a trial court judge, they're going to say, hey, this is the law in Arkansas has found this to be constitutional. I can't say it's unconstitutional, now, but lawyers got to make arguments for changes in law. So when it gets beyond the state level and back up to the federal level, that the federal courts say, all right, Arkansas has been not applying, their safeguards don't rise to the level of the protections the federal government has demanded be afforded to all citizens. All right, so moving on. Justice Alito, writing for the plurality.
You did it.
I know. So the plurality means that it's you don't have like a unanimous, you've got a split panel of the Supreme Court. So he's writing for Justice Alito was writing, argued the well-settled principles that fundamental rights guaranteed in the Bill of Rights are incorporated against the states by the 14th Amendment due process clause. Justice Thomas concurred with Alito's plurality, but he opined that complete incorporation was necessary by the plain language of the 14th Amendment privileges or immunities clause rather than the due process clause. So that's now that's another avenue. It's like, all right, there was a concurrence by Justice Thomas, which means I agree with what Justice Alito said, but for a different reason. So I'm going to concur. I'm going to give, I agree, but my reasoning's a little bit differently. So it gives another avenue. You've got the 14th Amendment's privileges or immunities clause rather than the due process clause. So in that concurrence, Thomas repeated this argument in the Ramos concurrence 10 years later. So that gives them two clauses kind of to pick from. Paragraph 34, regardless of which clause the court prefers, both analyses point towards finding that finding that the 14th Amendment requires Arkansas to strictly comply with the Fifth Amendment's grand jury clause. Strictly? Since the Hurtado court determined that the 14th Amendment due process clause governs the review of how a state files serious criminal charges against individuals, like the defendant in this case, and the Ramos court determined that the due process clause requires uniformity in the protections of the constitutional rights between the state and federal criminal justice systems. These two cases, taken together, suggest that the state's failure to comply with the Fifth Amendment's grand jury clause, incorporated under the due process clause, requires the dismissal of the felony information in this case. Likewise, since the plain language of the 14th Amendment's privileges or immunities clause provides that, quote, no state shall make or enforce any law which shall abridge the rights, privileges, or immunities of the citizens of the United States. The jury requirements of the Fifth and Sixth Amendment, both enumerated and unenumerated, protect individuals from deprivations of liberties imposed by an individual representative of the executive branch rather than a jury. The language of U.S. Constitution suggests that a state may not, as here, file felony charges leading to the arrest of an individual like this defendant with any process involving a greater risk of arbitrariness than putting the question to a grand jury. And that they're also citing that 2024, I think it was, U.S. Supreme Court. Ramos and other recent incorporation decisions demonstrate that it is just a matter of time before the Supreme Court of the United States incorporates the grand jury requirement and invalidates virtually every felony prosecution pursued in the state of Arkansas. I don't know about that. They may make a change going forward, but I mean, who knows if they find it substantive? Accordingly, the defendant respectfully requests that the felony information in this case be dismissed. Oh, it's still me?
Yeah.
No, C is you. We're on to C now,
No, it
sir.
was supposed to be two. Two was me, but okay. All right. So, Amendment 21 to the Arkansas Constitution violates the Fifth Amendment to the U.S. Constitution. Paragraph 39, jury trial rights exist to, quote, prevent oppression by the government, here, here, and to provide a, quote, defense against arbitrary law enforcement, here, here. And that comes from Duncan v. Louisiana, a 1968 case. Those who wrote our constitutions knew from history and experience that it was necessary to protect against unfounded criminal charges brought to eliminate enemies and against judges too responsive to the voice of higher authority, providing an accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against the corrupt and overzealous prosecutor and against the compliant, biased, or eccentric judge. 40, both under English common law and under the U.S. Constitution, the jury exists, quote, at the heart of our criminal justice system to, quote, ensure a judge's power to punish is derived wholly from and remains always controlled by the jury and its verdict. And that again comes from Erlinger, that 2024 case. 41, courts should act affirmatively to protect jury rights from encroachment because, as constitutional scholar Suja A. Thomas observed when she argued in favor of incorporating the remaining jury-related rights in 2012, parentheticals prior to the express incorporation of the jury unanimity right by the court in Ramos. The jury, and this is another quote, the jury shares with and competes with the judiciary for power, but the jury, quote, cannot do anything to regain power when the power is taken away from it. And that's end quote. So 42, as previously established, the framers of the existing Arkansas Constitution acted affirmatively to protect the grand jury right enshrined in the Fifth Amendment to the U.S. Constitution when they drafted Article 2, Section 8 of the Arkansas Constitution. However, Amendment 21 purports to take that right away. So one argument, it's a sub-argument here. One, when Amendment 21 has been challenged under the Fifth Amendment, the Arkansas Supreme Court has relied on a Hurtado, that damn Hurtado case, to affirm its constitutionality. I mean, they're arguing, look, you're using a piece of shit case as your precedent.
Right, and looks to me that Arkansas most recently relied on that case to I think it was in 2005. But we'll see, they may have something more in here.
Yeah. So 43, the Arkansas Supreme Court will strike an amendment to the Arkansas Constitution when that amendment directly conflicts with the U.S. Constitution. See example U.S. term limits v. Hill. And that was an Arkansas case from 1994, striking Amendment 73 to the Arkansas Constitution because it imposed an additional eligibility requirement on candidates for the Arkansas delegation to the U.S. Congress in violation of the 10th Amendment to the U.S. Constitution. And we've told you this many, many times on this channel. In terms of the federal Constitution, states can grant more rights to its citizens than the federal Constitution grants. It cannot create law that grants its citizens less rights than the federal Constitution.
As far
Always
as those rights that have been applied to the states through the 14th Amendment.
right. So always keep that in mind. So, nevertheless, in paragraph 44, in 1937, the Arkansas Supreme Court affirmed the constitutionality of Amendment 21 because of Hurtado and subsequent decisions relying on the same case. And then they cite Penton, which is a 1928 case, citing Hurtado for the proposition, which I thought Hurtado was a 1936 case, citing
18,
Hurtado.
18.
Oh yeah, Jesus, it's even scarier. Hurtado for the proposition that quote prosecution by information instead of indictment by indictment is quote not a violation of the federal Constitution. And that comes from Spees v.
No,
Illinois.
no, that came from the one you cited. Now they're about to cite Spies v. Illinois or Spies v. Illinois.
Spies. Oh yeah, citing Hurtado for the proposition that the due process clause did not necessarily require an indictment because an accusation by a preliminary examination was equivalent to an indictment.
Which they don't offer here. So that's talking about preliminary hearing. And that's what we do in Illinois. It's one or the other. It's not neither.
So yeah, it's not neither. It's crazy.
Unless
So
somebody waives it. They can waive it.
but that
That's
puts
different.
power in
Right.
the hands of the defendant.
Right.
So the Arkansas Supreme Court's subsequent decisions reaffirming Amendment 21 are based solely on the principle of stare decisis. In Gardner v. Payne, this court has held that Amendment 21 to the Arkansas Constitution, which permits indictment by information, is constitutional. And then
So
they
that's
also,
why I didn't see it, because they were relying on stare decisis and not quoting Hurtado.
yeah, McClinton v. State, this court has held many times that Amendment 21 to the Arkansas Constitution is constitutional. And then Taylor v. State, relying on Hurtado supra for the proposition that quote states are not required to charge by indictment, but may charge by an information. And then Ham v. State declining to overrule prior decisions regarding the constitutionality of filing federal charges in the absence of a grand jury. And then Caldwell v. State, finding no need to reconsider prior cases, finding Amendment 21 to be constitutional within the meaning of the Fifth and 14th Amendments to the United States. All right. And then down here, they get into the second argument too. Given the development of constitutional law since Hurtado, existing Arkansas precedent is demonstrably erroneous. 46. Notwithstanding the principle of stare decisis, the Arkansas Supreme Court will abandon existing precedents when they are demonstrably erroneous. And that comes from Kimbrough v. Grieve. And then 47, existing precedent of the Arkansas Supreme Court are demonstrably erroneous when they conflict with the U.S. Constitution as interpreted by the Supreme Court of the United States. And they cite some cases there. 48, although the Supreme Court of the United States has found all but one criminal due process right enumerated in the Bill of Rights to be fully incorporated against the states under the due process clause, the court has, in its own words, quote, shed any reluctance to hold that rights guaranteed by the Bill of Rights meet or met the requirements for protection under the Due Process Clause. And that comes from McDonald, 561 US 764. 49. In 2010, the court added to its list of enumerated rights that have been incorporated against the states by holding that the Second Amendment is fully incorporated against the states because the right to bear arms is, quote, deeply rooted in this nation's history and tradition. So, likewise, in 2020, the court held that the Sixth Amendment jury unanimity requirement is incorporated against the states under the Due Process Clause. Yeah, because when Lance's father told me about their jury system down there in Louisiana because they were following the French system, it blew my fucking mind. Like allowing jury splits in terms of criminal cases is crazy.
What was it that could it be 6? Did it have to be half? Did it have to be more than half? What
Yeah,
was
no, it was shocking. I'll have to, I can't remember what it was, but I was stunned. It was like, I think it was like you had to have like 8 out of
mm.
12. It was like, it was crazy. I'm like, what? I'm like, that's insane. Yeah, it changes the whole concept of it. 50, even a right that is not enumerated in the Bill of Rights may be incorporated against the states under the Due Process Clause. In 2024, the Supreme Court of the United States held that the common law right to be sentenced based only on a jury's finding of facts, quote, beyond a reasonable doubt, rather than based on a judge's finding of an additional fact based on a preponderance of the evidence, is incorporated against the states because it is a fundamental right. So, because the Supreme Court of the United States has abandoned its precedents related to the non incorporation of certain rights, neither Amendment 21 nor the principle of stare decisis prevents this court from dismissing this felony information as a violation of the Fifth Amendment's grand jury clause.
I'd have to say I would be incorporating in here, or, you know, to provide a preliminary hearing, although I'm sure they don't want a preliminary hearing in this case. They want it to go to a grand jury, but just as far as because it's one of those 2 things. So, is this enough to get them to consider? I think it probably is to get if it goes up to the Supreme Court to consider whether overall Arkansas's procedural process is, you know, rises to the level of substantive due process required under the federal constitution. But I'd still be saying, or grant me a preliminary hearing.
Yeah. All right. So, argument 3, existing Arkansas precedent is demonstrably erroneous because it leads to a result that is manifestly unjust. 52, in Arkansas, precedent governs until it gives a result that is so patently wrong or manifestly unjust that a break becomes unavoidable. And they cite this Hervey v. State case in 2006. 53, although Arkansas precedent is to uphold the constitutionality of Amendment 21 based on the 1884 Hurtado case, as applied by the Arkansas Supreme Court in the 1937 Penton case, this precedent has led to an absurd result. In Arkansas, a prosecutor, disappointed by a grand jury's refusal to indict an individual with a capital or infamous crime, may then turn around and file this serious charge unilaterally, directly controverting the demonstrated will of the people. So I'm going to read that again because that's where the heart of this thing is. This is where it's so scary.
Right.
So, just in layman's terms, what they're saying is in Arkansas that you have a prosecutor that could convene a grand jury, go in, grand jury's like, nah, man,
Hell no.
this ain't it.
Not a
Ain't
chance.
it. This ain't it, Bill. Like, we're
Ham
not,
sandwich, no.
no, denied. And that
Denied.
this dude could be all huffy and puffy. Well, fuck you. I'm gonna go file the information. And he can go in on his own with no one overseeing it, no one that can stop him after the people Because remember, a grand jury is made up of us, the citizens. The citizens sat in there and told them, "No, dude, no, no, do better, do better.
This ain't
Don't
the
do
one.
this ain't it." And that same prosecutor can then turn around, walk into court, and say, "Oh, here you go. Here's my information,"
Let's
and
go.
then he can write whatever he wants, give the same facts that a bunch of citizens said, "No, that's not enough," and you can get a judge up there and says, "Yeah, this looks pretty good," or he tinkers with it, gets the he gets the facts and the information to where he thinks the judge will say, "All right, we're good to go." That's
But
scary. That is
but
really, really scary.
the downside here is that that's not what happened here. So yeah, the court. So it's an argument that tells the court this is a slippery slope. This could happen, but it's not what happened here. So that is a negative as far
Well,
as this
yeah,
argument goes.
but it is and it isn't, because depending on what is typical in that particular county, like, say, for instance, they always go and convene a grand jury, and in this particular case, they didn't.
Right? I
It
don't know. Maybe
I
there's
don't know either. I mean, depending on what is typical, what is
right.
customary in that particular county, if they're always convening grand juries and they almost always go on indictments, if they didn't do it in this case, I think
It
this is a
speaks
pretty good
volumes.
argument. Um, and I'm sure that his lawyers are aware of whatever the typical move is. Okay, so directly controverting the demonstrated will of the people, and that comes from Orsini v. State, an 1985 case. So, paragraph 54, the executive branch of the government is the closest thing to the crown that exists in the modern United States. And a prosecutor is a representative of this crown.
Mhm.
The government, y'all, the government. It was against the crown, paragraph 55, against crown overreach that early Americans sought to protect themselves when they revolted and established the United States Constitution, and when they ratified the Fifth Amendment. Nevertheless, in Orsini, the Arkansas Supreme Court upheld the constitutionality of allowing a lone prosecutor to take a second bite at the charging apple by filing an information violating not only the grand jury clause, but also the Arkansas General Assembly's statute requiring good cause and the court's permission to go forward with felony charges after a sitting grand jury has determined no charges should be filed. So 57, Section D of this statute expressly requires, quote, unless an indictment is found at the term of the court next after the first submission of the charge to the grand jury, the defendant shall be discharged from custody or exonerated from bail unless, for cause shown, the court shall otherwise direct. And that comes from the code. Thus, according to the legislature, the only two permissible exceptions to the statutory requirement of discharge/exoneration are: one, if a grand jury returns an indictment, or two, if a court finds good cause not to discharge/exonerate the accused. In this context, Arkansas precedent regarding Amendment 21 and the Fifth Amendment creates a loophole that was not intended by the legislature. 58, this unintended loophole creates a manifestly unjust legal landscape wherein a person may be charged with a capital crime or other serious felony by an individual member of the executive branch who has already been told by multiple authorities, including two constitutions, the Arkansas General Assembly, and a jury with knowledge of the facts of the specific case, that the person should be allowed to go free. Scary shit, y'all. Did you say Arkansas is the only state that has this shit?
The only state. The only
It's
state.
crazy.
It's Connecticut. There are some felony offenses to which they can proceed just by and I've got to double check this. This is like quick research, but that um allows for lower level felonies them to go by way of information and not entitle the defendant to either grand jury indictment or preliminary hearing.
Mm. 59, both the manifest injustice of this result and the demonstrably erroneous nature of existing Arkansas Supreme Court decisions, parentheticals, given the trend toward total incorporation of all due process rights by the Supreme Court of the United States, require a break with existing precedent. And the court should dismiss this felony information accordingly. And then finally, they conclude 61, an individual's Fifth Amendment right to be free from serious criminal charges, except those charged by the indictment of a grand jury, shields not only this defendant, but all of us from exactly the sort of deprivations of liberty without due process that the framers sought to prevent. Rather than continuing down the path of affirming a prosecutor's purported power, even when it contravenes the express will of a grand jury to unilaterally charge people with capital crimes or other serious felonies, this court should look to the language and intent of both relevant constitutions with due consideration to the development of constitutional law in this area since 1884. And it should find that the felony information in this case violates the Fifth Amendment's grand jury clause as incorporated by the 14th Amendment. Wherefore, the defendant, Aaron Spencer, respectfully requests that this court dismiss the felony information in this case for violating the Fifth Amendment's grand jury clause. What could be more egregious? So there it is.
There it is.
It's a lofty argument, and like we were saying, it's one of those things where like this kind of case would have driven, like Allie writing this motion would have driven her fucking out of her mind. Allie's always convinced that she's going to be able to find precedent that supports her proposition. And sometimes the law is just bad. Like, and you're not going to find law sometimes. And it's one of the things that makes lawyering important is that lawyers can change the law. Like the problem here is, well, babe, let me ask you this. If this is filed, this judge looks at it and is like, nah, I don't even know what it means. It's very lofty, this thing. Like, remember, this is the judge that literally cut and pasted a gag rule from a case that had been overturned and used it as her fucking gag rule in this case.
Boy.
Gagging the whole world.
The whole world.
The world. Case. Bob and Allison Mata can go fuck themselves. They can't talk about Aaron Spencer's case, or I'm going to haul their ass into court in a jurisdiction that they don't live anywhere near, and I'm going to hold their asses in contempt. Doesn't work.
Contempt.
It's not how that shit works.
So she's doing it for the future.
Let me ask the question. Okay. So she denies it.
Right.
Is there the ability to do an interlocutory appeal on this type of issue?
What you're gonna like?
I'll put it to you.
But every state is different on what they're allowed to do, and usually the answer would be no. I now need to check Arkansas's interlocutory appeals on criminal cases. So,
yeah, because what's so disturbing to me is the fact that, because Alice and I were talking this morning, and she's always telling me, she's like, an information's not a fucking preliminary hearing. I'm like, I know that, but an information is the only way, at least because in Illinois, when you get a preliminary hearing, it's because an information was filed. It's because they did not go and indict through a grand jury. So in my mind, one is necessary in order to get the other thing. So here in Arkansas, the inability of a defendant to be able to request a preliminary hearing blows my mind. I mean, you literally have a situation where you have prosecutors that can come in with any bullshit. If they decided not to go to a grand jury to indict, they can just walk into the courtroom like they did here and say, oh, here you go. Here's the information. I haven't seen the information, or if I have, I can't remember what it was. And now that I think that I have, and it was super bare bones. So, like in this case, you can make it like, oh, this guy saw this guy driving, ran him off the road. This guy got out of his car, and then this guy shot him. There you go. Charge it without giving any of the other information. Because what we were looking at is, would a Frank's memo work here? And it would be the omission of facts. And again, it's only relevant to the facts that Aaron Spencer could have known at the time that the action occurred, that the crime occurred. And he knew what he knew. He knew that there had been the outcry by his daughter. He knew that Fossler had been arrested, and he knew that he had gotten out on bond, and he knew that somehow he had sunk his filthy predator claws back on his daughter and had his daughter out of his house at 12:30 at night. That's what's going through Aaron's mind that night. That's where he's at this moment in time. And that's all that, that they would be able to bring up in terms of a Frank's memo, where they're like, okay, well, we're looking at this information, and they didn't bring up any of these other things, which may, Your Honor, have swayed you to believe that this is a justifiable homicide, from that there was no crime committed here. That this person was doing what was right. Because you said that Arkansas is a stand your ground state.
Yep.
Yeah. So I don't know. I mean, I like this motion. I don't think it's going to be granted because, you're asking this judge to take a really big step and go against current precedent, what the law is, the law of the state at this point in time. Really, even though it appears to me, I agree with Aaron and Michael, the attorneys who drafted this, that the law is awful. It's terrible.
Yeah. Yeah. Horrible.
I mean, like, that law is like enough to have me never move to that state. I'm like, what? You could have any kind of crackerjack prosecutor come in there and write some shit up and get you, in jail awaiting trial. Scary. It's pretty scary. So, and where we sit here with the Aaron Spencer case, like, I'm dying to know the answer to that question. What their normal protocol is there. Do they typically go to a grand jury, or do they typically do it by I mean, if I have the option of not going to a grand jury and I can just write up some bullshit and information without fear of having a preliminary hearing, I'm doing that all the time. You know what I mean?
Right.
Like, why take that? Like, in this case in particular, even though the prosecutor would have had control of what facts were getting told to the grand jury, if they're allowed, I'm assuming, like most grand juries, they're allowed to ask questions. The grand jurors can inquire.
Oh,
So
yeah. Grand jurors.
So if this prosecutor would have left some important facts out.
Yeah, they would have been asking questions like, wait. How did the girl get in the car? How's she know this guy?
Who is this girl?
Who's this guy? How old is he?
Wait, this guy's 67?
What? How did he get her?
What time at night was it? What? How did he know this girl? Wait, what? He had been arrested for assaulting her? What? It's like those kind of questions would have come out. It's a frustrating case, and I really give a tip of the hat to both Michael and Aaron for taking a shot at this. I mean, they write it up and they know, but frankly, it was an important motion to write because it's the kind of case that, like I said, God forbid if Aaron was.
My quick glance, by the way, babe, you've got no right to appeal in a criminal case unless and until you're convicted.
There you go. So if the worst thing possible happens and Aaron is convicted, this preserves the record for this issue to make its way potentially up
to the Supreme Court of the United States.
The Supreme Court of the United States. And they're like, okay, Arkansas has now made it to where, we're gonna have to put the foot
Bitch
down.
slap
Here. That shit's crazy. What y'all are doing down there is crazy. So, I mean, we'll see. I don't know when this is. I don't know if the state has responded yet. It's such a lofty argument. I mean, the state's going to basically just puke up because they got in front of the counter arguments, which is that the law is currently situated is against us.
Right.
talking about the defense. So, they talked about it, obviously. So,
Which you're supposed to do whenever
yeah,
you're
yeah,
presenting an issue to the court, although we've
every
seen
time.
prosecutors not do that recently.
Well, and I mean, you want to do it because you want to be able to say, okay, well, you want to rebut their argument ahead of time if you can.
Right.
Say, okay, well, they're going to come at you with this bullshit, and this is why it's bullshit.
Right. Yeah,
You know,
the prosecution's gonna respond with, "As the defendant has,
right?
agreed, this issue is well resolved under Arkansas law, so go F yourself."
Yeah. So, I know Tracy's been dropping links for supporting Aaron and his family in our chat. We highly encourage you to do that. I know there's also a petition out there. I would be surprised if Tracy hasn't thrown that in here. If she hasn't, I'll get it and I'll throw it into the description of the show. Oh yeah. Yeah, Tracy, of course she did.
Mm.
She's the fucking shit. She the best. She the best. So do all the things. Do all the things so that the Spencer family knows that we got their back. Because
Yes.
Allie and I 100% have the Spencer family's back here. And like I said, as this thing starts to pick up steam, there was a trial date that was set that got continued. It looks like it's going to be early next year, I believe, if I'm remembering correctly. It may be in December, in terms of the trial date. Because like I said, and we talk about it all the time here, that part of the punishment is the pretrial phase of any case. Like these people that are standing trial that are presumed innocent are living with this concept that my life could be completely destroyed or altered like in the next 2 months, and it's never not at the top of your mind.
Right,
You're
and you need
all
money to mount a defense, you know?
yeah.
So, all right, people, thank you all for being here with us this
Yeah,
Saturday.
Allie
It's
and I
time
are
for Bob
going
and I to have
to,
fun.
Little George Porter tonight. If
Gotta
you
get in
know,
the
you know.
shower. I
If
gotta
you
get in
don't
the
know who
shower.
George Porter is, shame on you, first of all.
Shame.
And fix that by going and listening to the Meters, because he was the bass player for the Meters, which is probably my favorite band. So we're excited about that. We're celebrating our dear friend's birthday tonight. So it was wonderful. It was wonderful to spend a little bit of time with you all on
Did we
Saturday.
get all the stick supers? I'm sorry.
I think we did.
Okay.
Maybe a couple post punk mama. Aw, family hug. We love
Thank
you.
you.
Debbie,
Thank
$5
you.
super. Thank you. Aaron Penner. I'm new to the live chat. Welcome. Welcome,
Yes.
welcome, welcome. Thanks for the Saturday live. Thank you for joining us. We love lurkers, but we've got the best chat in the land. You should feel very comfortable coming here and speaking your piece.
Speaking
Speaking
of
your
peace.
piece. That's what we do our very best to make sure that this is not an echo chamber. All thoughts are welcome as long as you're not a douchebag. If you're a douchebag,
Can't
leave
help you
the
if you're a douchebag.
if you're a douchebag,
Danny
leave the microphone.
says, I appreciate your time and energy you put into your lives. I enjoy the chat so much. Thanks,
Yep.
Danny.
And then GV, member for 4 months. Massachusetts.
Hmm.
Why didn't we think of that?
Yeah.
There's a lot they
Let's
didn't
take
seem to
some
think
more
of.
rights. She's saying they're like, okay, yeah, we want to charge people without having to go to a grand jury or an indictment.
Yeah, and Travis, one of our ride or die resident attorneys, he always has great thoughts in chat. And I thought this was interesting. He says, where this issue um, shows its ugly face is that what states must adopt at due process comes up in jury trials, so that a state only has to give a jury trial for felonies. And that is an issue. Like, I mean, there are states where if you're charged with simply a misdemeanor, you cannot demand a jury. It's a bench trial. So it is a thing that pops up in different states, and jurisdictionally, every state's different. So just wanted to pop that up there. All right, mods, we love your faces so much. All of you beautiful humans, please know how much we love you. We adore you. We cherish you. If you really love our channel, think about becoming a member. We love our members. Maybe even just a little bit more. I kid. I don't. Because I know there's people that are out there that would love to be a member that maybe financially that's not doable for them. So we love you all the same. But
Yes, just subscribe and ask your neighbors, friends,
yes,
coworkers, family members
like,
to
share,
subscribe.
subscribe, the triangle. Like, share, subscribe.
It's free.
We call it the YouTube triangle. Like, share, subscribe. All right, you guys, we love you. We will see you. I'll figure out something for Monday. It'll be good times. But
Wait,
I'm going to the Bears game. It's going to be
Sunday, tomorrow, we're doing a members only.
what?
You said it. You're like, you promised the
Why do
people
you keep
last
putting
week.
bullshit on me, man? Did I say that?
You said it.
It's
You
gonna have
said
to
it.
be at like 7 in the morning, Joe. Tomorrow is football day.
Bob's
Football day.
revoking his previous promise.
Yeah. Oh, wait. So you're not liking that 7 a.m. thing?
Oh, if
We
you
could do
really
it
want to
early
do it at
live.
7 a.m., I'll do it
We
at
could
7
do
a.m.
we could do a earlier. I'm gonna wait till Murder Church is done over at Publicly Buzz, but when Steve's off, I'd jump on for a hot minute. And we could do some kind of fun members only thing.
We'll see.
Maybe like a little straight up
Sounds less
Q&A.
committed.
We could do a straight up Q&A members only where the only thing we talk about are questions on anything that you
That the
guys
people
have
ask.
that you're asking us in chat. So that might be fun. That might be cool. That might be
Cool.
cool. All right. Well, so keep your eyes out. If you're not a member, become a member so you can come hang with us in the what up, Sleuthy? You late, girl.
Well,
You late.
sorry.
All right, y'all. We love you. We will miss you. We will see you soon. Because without y'all, I'm just an old man.
Sitting around talking to his wife.
Boop. Boy, you're really been stuck on that one. Like up the game. Like
I
you've
like
been-
that one now.
You're like mailing it in on that. Like our little last catchphrase. You're just like mailing it in. I love you. Bye.
Mm-hmm.